Yeah, this one, it's come up a lot recently. I think probably because people were trying to file before the deadline. But there's so many different pieces to the homestead exemption on a property tax side, as well as, creditor protections. I think it's interesting to explore it.
I get a lot of from people moving, say, from Connecticut to here, not wanting to be taxed in Connecticut when they die. That's something people generally don't look at. What does Connecticut require for you to terminate their residency of Connecticut? And everybody comes down thinking it's 6 months in a day.
All right, so let's get started on that. That's a good transition. That's a good place to start. 6 months in a day is something that we hear all the time, from New Yorkers and people from Jersey and now Connecticut. That is kind of ingrained in them. But Florida has no time requirement to be considered a Florida resident. In fact, if you look on the website for the Collier appraiser or the Lee County appraiser, it actually tells you that there is no requirement of that. What are some of the good examples? Wasn't Derek Jeter? He was sued by City of New York.
This is the state of New York. I have an article on this on my shelf, Christian. They look at it's a substantial presence test in New York. How many contacts you have with the state. They don't want the people from New York to terminate their residency. They want to hit them with an estate tax. They want to hit them with an income tax. People just look at the federal level. And from a federal perspective, the U.S. government doesn't care. They're going to get you wherever you live. But Connecticut, Massachusetts, Illinois, places like that, they usually have a state statute that lists, 20 to 30 factors that they go through to see whether or not you are a tax resident of the state of, say, Connecticut, which is the last one I was asked about, for estate tax purposes, plus income. Jeter got nailed for income.
Well, yeah, he was trying to say he was a Florida resident, right? So this is the Collier County homestead brochure. Every county in Florida will work generally the exact same way because it's based on a Florida statute. But I like highlighting this part to clients. There is no time limit for Florida residency, not 1 year nor 6 months and 1 day. So I always tell people is when you get off the plane, if you want to be a Florida resident, just raise your hand, just ask.
It's 5 minutes. I tell people, especially in Collier, you get people who have 6 homes. They're not 6 months anywhere. The super wealthy folks, they can spend a month, in different homes throughout the country, throughout the world.
Yeah, absolutely. So let's talk about what Homestead does. I'll talk about the tax side of it, if you'll kind of point to the garnishment side of it. So on the tax side, the thing that really will help the most people is that it gives you a $50,000 exemption on appraised value. So if your house would otherwise be appraised at $500,000, they'll tax you as if it was $450,000. So they give you that immediate little savings right off the top, and then they limit how much the county can increase the appraised value each year to the maximum of 3%. The consumer, it's like it can't go more than 3%. Sometimes it could be even 0, but it definitely won't go more than 3%. And so I always look at your house, Dad. You've owned it for 20 plus years, and your taxes, because of that 3% limit, your tax bill is lower than mine.
My tax, we bought ours January 1, 1996, and we're paying maybe 1/5 of the taxes that anyone else would be paying. You, crying out loud. Your house has doubled, at least. Yeah,
and luckily I have the homestead exemption on there because I had the savings, and then when the price went crazy and it doubled essentially, my taxes are still pretty low. They're more based on what I paid versus what it's worth. If I did not have the homestead exemption on the property, if it wasn't my primary residence, then my tax bill would have gone up significantly more.
I do think it's fair that you pay more than me, though. It's only right.
It's only fair, right? Only fair.
Pay your share.
All right, so let me show you guys kind of how this might work. on, and again, we're talking about the homestead tax exemption. So we're going to do Collier County because it's where I live. And you can do this for yourself. I usually recommend you do it for yourself so that you can kind of figure this out before you kind of work through clients and kind of go from there. So in 2021, they valued my property. Let's see if we can get it bigger at that. And then I bought it and they upped the appraisal. So anytime there's a conveyance, the county has the right to reappraise the property. Basically, it loses that homestead protection if there was one, but also it gives the county the right to just start over and say, all right, well, you paid, $1 million for it. This is your new value. But then going forward, that's when you'll really get that savings. So for 2022, I did have the homestead exemption. Let's see, first homestead here. So 25,000 and 25,000. Basically, the total exemption amount is listed here. If you guys can see my cursor, it's a $50,000. You look at it, it's almost like a bill at a restaurant. Some things you're gonna, or maybe at a grocery store. Grocery stores, you get taxed on prepared foods, but you don't pay sales tax on unprepared foods like fruits and vegetables. So it kind of works the same way on a tax bill. Some things are going to get the exemption and some things will not. Specifically, public schools, you don't get the full $50,000, you get the half of that. And then it's going to limit how much it goes up. So it's at 2022, it was $1,079,431. Who knows how they came up with that number? But then 2023, which is not out just yet, the max it could go up is 3%, even if my property is worth $2 million. So 3%, do my math here. That's kind of the number, 1,111. So that goes up. But if it were not that, what would it do? So if it wasn't a homestead, there's now a cap on some of it and not a cap on the rest. So think of the bill as in two different pieces. You have school taxes and then you have non-school taxes. And I'm not going to say it because I don't remember exactly which one, but one of them is limited by a 10% increase every year. The other has no limit. So if it was now a $2 million property, your tax bill couldn't go up to the full 2 million, but it would get taxed a 10% maximum increase on half the bill and no limit on the increase on the other half. So it can really add up. And in my case, here's how you would calculate this. I think my millage rate ended up being this number here, 10.14. Now I'll slow down. This is a blast from the past. This is going back into your real estate school. So millage rate, how fun. Just as a reminder of how you calculate this, you take your millage rate, 10.14 in my case, and you multiply it by the thousands of your appraised value. So you would say 1,079 times 10.14. And that'll give you your tax bill for that year. That's how they calculate it. And so when we do any sort of deal, we kind of have to run that calculation to give the buyer an estimate of their taxes, because it is not based on what the seller was paying in taxes. It's going to be based on what you paid at closing times the millage rate, essentially. So we have Dad, we had a deal yesterday. The buyer was looking at two different properties. One was, I'll just round it, $5 million property, Marco Island, or a $5 million property in Fort Myers. And they're like, we like both, but the one on Marco has a much lower tax bill. So we really like that. And I said, right, well, don't get used to it. Yeah. So you might be able to keep that tax bill low for 2023 because we're already in April. But when the things get reappraised in 2024, because you just had a sale, the county's going to catch up. And now they're going to be taxing you on a $5 million property. And let's say it's a similar millage rate of 10 on that property. 5 million times 10 is going to be about 50 grand a year in taxes. And Fort Myers is going to do the exact same thing. The only difference would be, that Fort Myers property might be 9.87 millage rate and Marco might be 10.14, something like that. So you have to recalculate. You can't let your buyer assume that they're going to get a savings by going to this property versus that. It's really more of what you pay for it, and then whether you're going to have homestead or not.
I always tell the buyers too, you got to look at how long the owner owned the property, because if they're buying my house, it's been 26 years, it's going to go way the heck up.
Yeah, so let's look at your house, Dad. Let's say someone were to buy your house for the $1 million, just like they did mine. They pay $1 million for the house, but your tax bill is like $3,000 because you were based on kind of what you paid plus the 3% increases every year. So you've been paying $3,000-$4,000 a year right now. The new buyer pays $1 million for your property, but you had homestead. Shouldn't that protect them? And the new buyer is going to have homestead. Shouldn't that protect them? No. It will protect them for this year because you've locked in your homestead exemption for 2023 because we're now in April, but it won't protect them next year. The county has the right to reassess. They'll base it on your new purchase price and the millage rate, and they'll come up with a bill around 10,000, something like that. So you just don't want your buyer assuming that in the sense, and if they have questions about taxes, you should lean into us and let us do a calculation for them, or you could absolutely run the numbers. And I always like to overdo it. So if the buyer is paying $1 million for a property, I'm going to assume the county is going to charge them at the $1 million. And so I'll do the full amount, when in reality, they might do it at $950. So, and then if you have the homestead, it would definitely go down from there too. It would go another 50 down from that. So that's the tax side of it. Dad, can you give a kind of little summary on the garnishment side of it?
Love the garnishment side of it. Florida's one of, with Texas, one of the states where your homestead is exempt from creditors levy, no matter what it's worth. I mean, it's limited to certain geographical sizes, whether you're in a city or outside a city. But in Florida, and I always use O.J. Simpson as an example.
Who's that?
Some guy who played football years ago.
That's right.
And got a $40 million judgment against him when his ex-wife got killed by somebody. Anyways, so he moved here in theory.
Moved to Florida.
Right, and he moved just north of Miami. His home was exempt from creditors levy, so his kids had a place to live. And his NFL pension and his actor's pension was exempt from levy as well. I mean, there's a whole list of things exempt from creditors levy when you are a resident of Florida. Now, the only exceptions with the homestead is, your mortgage on your home. If you hire somebody to do work on your home, like a new roof, and you don't pay them,
contractor,
mechanics lien, or the IRS, they go after whatever the
property
heck they want.
Taxes, maybe. Yeah,
property taxes. Well, they'll sell tax certificates, but other than that, your home is exempt. Your 401k is exempt. If you run somebody over, God forbid, on the way home from work, anything you jointly own with your wife is exempt. Annuities are exempt. So there's a whole slew of things that are exempt if you're in a high risk business, or if you're just a bad driver like me. I shift things around so that your mother is safe.
Well, and so there's a saying, I don't know if you've heard this, Dad. Florida is a sunny place for shady people.
Thank you.
For that reason, right? So ultimately, if you were to get sued in Florida, they can't attach a lawsuit or a judgment against your home property, your homesteaded property. And that's a huge benefit for people that are in very risky businesses, even businesses like our own or yours as realtors. That's a huge benefit to say, all right, I have a lot of assets tied up, a lot of equity tied up in my primary residence, and that's judgment proof. It's a really wonderful thing. And as people that are going after you, they know that as well. And so they may decide not to even sue you, knowing that all your equity is tied up in a homesteaded property.
We've had a few cases of realtors who, and you'll run into this when your kids are older, they buy a car and they keep it in their name because insurance costs so less. Then their child gets in a car accident and somebody gets killed. I know multiple cases where that's happened within the company. They've gone after other properties and gotten them, but they couldn't touch the homestead. It was horrific. I mean, you don't want to take a human life no matter what, And in some cases, and in fact, you probably know these people, one that your sister went to school with, she hit somebody going down Airport Road when she was in high school and killed a young mom.
Yeah, yeah.
Broke up the marriage.
So
Everything.
it does have real world, you know, kind of impacts for people, and some people are going to be more worried about that than others. So let's go to the third part of this. So those are really the two things that homestead protections in Florida give you. Now, I'll tell you, even other states that have something called homestead, it usually doesn't work with both of those like it does in Florida. You know, so if you're in a different state and you have homestead there, it probably only does the property tax exemptions and limitations. It most likely doesn't do the judgment proof part of it or the garnishment side. Florida's unique in that sense. I'm not aware of other states that have both of those.
It's usually a dollar limit, like Massachusetts with your aunts. We've been through this. I mean, there's a certain dollar amount that Massachusetts will allow them to protect if they go on the courthouse and file certain papers, but it's not unlimited in value. So,
so it's a pretty good thing. So let's talk about the third part of it. How do you do homestead? How do you get it? Who's it for and who's it not for? First and foremost, if it's your primary residence, then you should apply for this. And how you do it, you go down to the county. In Collier County, there are like 6 or 8 different offices that you can do it. The one closest to our office is on Orange Blossom Drive. And you can get your driver's license, car registration, voter registration, and homestead all in like an hour. And so I send every client I can to that office. They do a great job, and you can rent a book at the library that's there too in the meantime. So it's really easy. You don't need an attorney. You can go down and do it yourself, and it's a simple application that you fill out right then and there. And they give you a receipt, basically a piece of paper saying, here's your certification that you do have homestead on the property. You have to do it in order to get it for, let's use 2023. In order to have homestead on your tax bill for 2023, you had to apply prior to April 1st. I think prior to April 1st of 2023, you would have had to have applied. You also would have had to have owned the property as of January 1st of that same year. So you own it January 2023, you apply it by April 1st, 2023. So if you didn't buy it until March 1st, you can still apply, but it's not going to attach for 2023. It's going to attach to your tax bill in 2024. But if it's your homestead, you still get the garnishment side of it. So I still recommend clients go down and apply, get the protection. You don't need to apply to get the protection, but you do need to apply so you don't forget. You don't forget to apply. You don't have to wait till next year. You just have to have all those things lined up. Apply, own the property before January 1 and apply before April 1. If you did that the year before, great, you're golden, you're fine. So now we talk about the next side of it. We talked, Dad, about the fact that you don't need some sort of time limit. And so the issue that I keep being asked about is, oh, well, I'm a resident of New York. I spend most of my time in New York. I would love to file for the homestead, but I can't. I don't live here. And so, and this might be a little bit controversial. Dad, I'll be interested in your take on this. Here's my take on it. You can become a Florida resident just by raising your hand. So I usually suggest my clients do it. Raise your hand, become a Florida resident, sign up, get the paper, get your Florida driver's license, register a car, file the application. Let's make it happen. Go do it. Just don't assume that you'll be able to avoid income taxes in New York. So New York, in that example, looks at you as to whether you are subject to New York income taxes based on some sort of residency requirement. And residency doesn't mean you have a New York driver's license. It means you spend a certain amount of time there. You're going to be subjected to their taxes, whether you consider yourself a New Yorker or not. And so I tell people, I say, make sure your accountant understands what you're doing. Make sure that they know if you have to pay New York taxes, then you have to pay New York taxes. You're doing it for this other reason. I'll pay my taxes, fine, but I want the creditor protection and I want the property tax exemption. So you can still do it. And that's my argument, at least. I think you can still do it. You get your accountant to sign off on it, get your attorney to sign off on it, and you apply. It's funny, people push back on that because they don't want to give up their driver's license. I couldn't imagine giving up my New York driver's license. Well, until I tell you the math. So Dad, in your case, your tax bill could very easily be $20,000 a year, but it's more like $3,000 a year. Right. That's huge. So savings of $15,000, $16,000, $17,000 a year. Is that worth holding on to your driver's license? That's up to you. That's
well, the income tax is huge. There's an article on my bookshelf in my office, Christian, January 8th, 2020, and it compares New York, Massachusetts, some other state, and Florida on people making $500,000, $1 million, and I believe $2 million. And it shows the difference in taxes. But the interesting part is at the end of the article, it applies what I call the substantial presence test. There's a substantial presence test in the Internal Revenue Code for non-residents of the country. And New York seems to be applying exactly the same thing. They look at, in this article, they went through 17,000 cases, over 50% of them were denied. And they're looking at like, where do you keep your artwork? Where do you go to the doctors? Where do your kids live? Where, all the touches that you have with the state of New York.
Yeah, where's your mail sent? What do you put on all your stationery? They'll look at everything.
So I give the article to people and say, just talk to your accountant, get the New York statute, and you'll find the factors. I mean, it's a whole bunch.
And it's also why I tell clients, I am not telling you to stop paying New York income taxes. That's not what I'm talking about. I'm saying that you might still be able to get the homestead exemption. They are different, just like the garnishment,
totally different.
The property, they're different. Well, income taxes and homestead could be different as well. And so that's what I look at. We have a couple of questions. Would homestead affect any future loan processing or other properties or investments? Maybe, right? I can't give you a blanket no, but I kind of lean towards the no. I don't think it should affect anything. For most of your loan documents, we're talking about intent at the time of closing. So if you buy a house in New York, we keep using New York as the example, it could be any state. You buy a home in New York and it's a primary mortgage, a primary residence mortgage. Basically, you live there. You're going to get a lower interest rate. And so you have to sign something at closing saying, I will inhabit this property within 60 days of closing. That's kind of the standard Fannie Mae, Freddie Mac guidelines. At the time of closing, it's all about intent. If you, a week later, talk to your attorney or give me a call and I convince you somehow that you should become a Florida resident, it doesn't affect what your intent was a week earlier. So I would say it doesn't affect those things, but you do need to ask. You need to get advice. It needs to be specific to your situation, but generally it shouldn't affect those things. And Dad, to your point, the only reason New York's looking at those factors is because you decided not to pay New York income taxes. But if they got their check, they're not going to look for you. They don't care. There's no upside to them anymore. Here's another question. Does the creditor protection apply to a business owned in another state? If you own a home in Florida, but a business in Massachusetts, does declaring homestead here protect that business? No, it doesn't protect the business. It only protects the home. So the judgment would still be of record. You would still owe that money according to the court. It's just that the creditor couldn't take your house to pay for it. They couldn't do that. But
they could go after your shares in the business. I mean, they
could go after your shares in the business. They could go after your car, your bank accounts. They could go after your firstborn children. They can do that, right?
How about my thirdborn?
Thirdborn, no, I don't think they allow that. But yeah, so a Massachusetts business that gets sued or that you get sued because of your involvement in a Massachusetts business would not affect the property that you own in Florida if it is homesteaded.
People in Mass are way too nice to sue people.
That would never happen. That's right.
No.
So that's very interesting. Now I've had, let me see if I can share my screen again. I've had a lot of questions come up about this recently. And one of the questions that came up was this here, loss of homestead, rental fraud. All right, so Florida state statute requires that you have legal or beneficial title to real property and in good faith make the same your permanent residence as of January 1st to be eligible for the homestead exemption. In this case, if these requirements are not met, there would be a loss of homestead on the property. After you were initially granted the homestead exemption, a receipt will be mailed to you each year in January to verify status, use, and ownership. If you do not receive this renewal receipt and fail to contact our office, it could result in the loss of your exemption. Basically, the counties know that this is really valuable because if you are deemed to not be living in that home anymore, Dad, they're going to raise your bill from $3,000 to $15,000 like overnight. And so that's really beneficial to the county. They want that. So they're going to stay on top of it and they're going to audit these sorts of things.
We actually had that, Christian, with a client from California who fraudulently declared homestead on a Port Royal property. They were trying to cap future increases.
Sure.
And foolishly, they wrote to the appraiser's office contesting their current capped bill. And they made reference to, send any responses to our home here in California. And the county actually sent somebody out to the house, looked in the windows and found out there was no furniture in the house. So they revoked the homestead exemption. We still represent these people, by the way, but it's like, they got a little greedy on the current cap bill and they ended up losing the whole thing.
Well, and so keep in mind also, there are different people that are going to be trying to break through your homestead exemption. One is the county. They want their bill, they want their money, but also it could be a creditor trying to break through your homestead protection. The creditor could be going down to the house and seeing if there's furniture. So it's interesting to see who's kind of motivated to break through this. So this came up recently because I have a client that owns a very expensive home and has owned it for 20 years. And it's gone up in value. It's probably a $5 million home at this point. But this year, he got an offer to rent it. He's not staying at the property because I think his girlfriend lives down the street and he can stay with her. And someone offered him $100,000 a month to rent it for 3 months. And he's like, okay, sure. So he rents it for 3 months, $100,000 each. He's living down the street. It's fine. He'll be back this summer. And he calls me panicked. Did I make a mistake? Because if I give up my homestead exemption, I paid, $1 million for it 20 years ago. Now it's worth 5 million. Will my bill go from 10 grand to 50 this year just because I rented it out for a couple of months? And interestingly, the answer is no. His homestead will be protected as long as he doesn't do it again. As long as he doesn't do it again. So this is interesting. Here it is. Florida state statute, rental of homestead to constitute abandonment. The rental of all or substantially all of a dwelling previously claimed to be homesteaded for tax purposes shall constitute the abandonment of such dwelling as a homestead, and the abandonment continues until the dwelling is physically occupied by the owner. However, such abandonment of the homestead after January 1 of any year does not affect the homestead exemption for tax purposes for that particular year, unless, and this is the interesting part, the property is rented for more than 30 days per calendar year for 2 consecutive years. I thought this was fascinating. Dad, honestly, I didn't even know how this worked until the client asked. I had to kind of educate myself about it.
I never actually saw that, Christian. What I see is people get to be older and they get sick and they have to temporarily move in with their kids in Minnesota. Do they lose their homestead exemption? And typically, as long as it's a temporary thing and they intend to move back to Marco or wherever, Naples, wherever it is, they should not. It's just documenting it. You want to make sure you have it documented that you intend to go back home once your broken hip heals or whatever the situation.
Well, I think what you could imagine is, let's say you're not there, you're trying to get healed, and so you decide, all right, I'll do a seasonal rental. There are a couple of interesting points. It's only a couple of sentences, but it's actually somewhat complex. Number one, remember there are 2 parts to the homestead. There's the garnishment side and the tax side. So I told this client, I said, if you were sued and they got a judgment while you are renting the property out, you can't claim the homestead protections for that lawsuit. You can't protect you would not get it back until you physically occupy the property again. Now it's only 3 months. He's not being sued by anybody. He's like, I'm not worried about it. I said, great, perfect. So let's put that aside. You have no protection against creditors while you're renting it out. I said, the second part is property taxes. When did you rent the property to this party? And he said, it was February 1st. Great, that's good news, because as of January 1, you occupied the property as your primary residence. You were not renting it out. You did not move out. You were still occupying. So as of January 1, you had met all the requirements for tax purposes to get the exemption. The tricky part, just don't do it again next year. And so it says, the property is rented for more than 30 days per calendar year for 2 consecutive years. So you could rent it out for pretty much, 11 and a half months in this year. Just don't do it for more than 30 days next year, and don't let it be rented on January 1st. It's a little weird, but it makes sense to me also. The county is worried about what was the January 1 status from one year to the next, and how many days in total did you rent it out? And that's how the statute is written. So that's going to apply across the state regarding the exemptions for tax purposes. I thought it was really interesting. I have one other example, Dad, if you'll bear with me. So on this other example, we have a house that was damaged. It wasn't actually damaged in the storm last year, but it was damaged in a fire. But it would kind of work the same if it was damaged in a storm. The house had to get demolished. And the owner got a check, an insurance check. And they said, well, that's my homesteaded property. I said, well, it's vacant land. Is it your homestead property? And they're like, well, I don't have any other homesteaded property. I'm renting. I said, well, someone could argue you don't live there. You don't, but there's a statute out there regarding this particular thing, this kind of scenario happening. If it was something, I think that the word they use is reasonable. Are you taking reasonable steps to rebuild the property and occupy it again? Is it your intent to do all of that? And, reasonable test, that's a tough one. I'd rather not be in the middle of that, but that's what it was. And then separately, when she got the insurance check, there's case law saying that you should put this money aside, that you should put it into a separate account, that it's not commingled with any of your other money. And if you do that, there's case law that says it will be protected. That money from the insurance proceeds will still be protected. And Dad, it works the same way with a sale. So if you haven't bought something right away, you can take all your sale proceeds and keep it separate, and it could still be considered protected from creditors.
Yeah, you document it, you keep it segregated, you don't commingle the money, you show in emails with your realtor or your lawyer or you, gee whiz, I want to build a new house. I love Marco, Naples, whatever it is. And just document it. Assume you're going to be audited and garnish a lot of paperwork.
So then there's another issue that came up recently. There was a case, and there's an attorney in town that was sending out an email talking about this case. And it was specifically about when you transfer a property either from an LLC or into an LLC, that it could reset and allow the appraiser to assess the property at what it's worth, basically taking away that homesteaded protection. And the court found that it would allow the county to reset the appraised amount.
This is the dock stamp case, isn't it?
This is a newer case. I think the dock stamps is very relevant. So dock stamps are what's paid anytime you transfer a property for value. And, if there's no mortgage, usually you can avoid paying dock stamps when it's, your entity to your entity, there are all exceptions to it. But I think in this case, Dad, you're right. There were dock stamps that were paid. So the county gets paid on a conveyance, and they looked at it like, all right, now we can reassess the property. And it jumped the value of that property by like over $100,000 seemingly, because now they can reassess it. So it was, I think context is key. The details matter. Big key on that is usually you don't have a homestead protection when it's in an LLC anyways. You can do it, but most people don't Don't
It's got to
do
be a
it that
trust
way.
or individual. You can't put it in a corporation or an
Right.
LLC.
You can only do it if you have like a 99-year lease, and not many people do it. It's possible though. It is possible. All right, so that's Homestead, and there's so much to it. It's such a wild thing. It has other sides of it, spousal protections, and if it's held in trust. Dad, you mentioned a trust. You're still going to have to sign individually if it's homesteaded at closing. This statute
It gets very
is wild.
complicated.
It's
With the
wild.
trust, you got to make sure who the beneficiaries are, that it doesn't violate, Article 10, Section 4 of the Constitution. So you have your estate planner look at it.
And so that's a key also. I always talk to buyers and they're asking questions about trust and this and that. And I say, if you haven't talked to a Florida estate attorney specifically about homestead protections, you need to, because it could, if you file for homestead and it's in your trust and it's a Massachusetts trust, it's not accounting for Florida homestead. And that has these tentacles that just get into everything. It could totally invalidate your trust. How scary would that be? That would not be good. We do have a question, Dad. What if you rent out another residence on the property? So I guess if you're not renting out the entire thing, you could claim to still be protecting yourself. The language from the statute says the rental of all or substantially all of a dwelling.
Well, you get the duplexes where people rent out one side, and the county comes after you for the part that you are renting out if you're doing it regularly.
What I would recommend in that case is you call the county and you talk to the homestead person. They're actually pretty good about it. They're easy to talk to. You can go down and meet with them in person and get their opinion. Even if even if they change their opinion later, you kind of get the spirit of it, and you say, all right, well, this is how they're doing it. This, that makes sense. Let's, and then you get to decide to do it or not. But it really does matter who is implementing the statute. As much as the statute matters, you don't want to be in a lawsuit. You don't want to have to make the argument. You kind of want, what is their opinion initially?
And when you do it, get the name and number of the person you spoke to, so that if they do come after you, you can say, well, I spoke to Joe Blow at this number and he said, X, Y, Z. And they, that helps with, ethics complaints, with really anything. Document who you spoke to.
Document who you spoke to. Well, I was going to get into seller's disclosures as well. I'll do a 2-second thing and then we'll probably end. We can do seller disclosure another time.
Those are good, right?
Yeah, it's good. So seller disclosures are good. Actually, that's the answer. We always recommend it. It is not legally required, but there are reasons we do it. It protects the seller. So the seller should be motivated to fill out a seller disclosure, and that's whether they're selling it for sale by owner, that's whether they're selling it with a real estate agent, or otherwise, whether they know anything about the property or not. Show them the form, ask them to complete it, tell them it protects the seller, and if there's anything, if it jogs anyone's memory, they'll put it on there, and that will also help the buyer. And so I just don't see it any other way. It's so simple. Dad, quick question. Is it a statute or was it case law?
Case law, and there's a statute on the agents. The agents are bound to disclose as well. So if your client says, I don't want to tell them that my house got flooded by Ian, the realtor has to disclose it. So that part is statutory.
Exactly.
But Johnson v. Davis was the case, and we go way over. I mean, I'm doing that now with, my best friend. They're selling their home on Marco, and because the guy is so prominent and he's such a big target, I always assume that after the closing, if the buyer, has setbacks or has a change of heart and they don't like the property as much, they're going to go looking for a reason to sue him. So you disclose like crazy.
Yeah. But they couldn't sue him and take his new home, so he's okay
there. No, but he has a bunch of other homes, so that's a problem.
I know. All right. Thank you, everybody, for coming. I'm so glad you stayed on this whole time. If you have questions, call or email us. Happy to help. But this is something that I would recommend every client look at to see if it would work for them, because I think it usually does, and they may not realize it. All right. Good luck, and call if you need us. Thanks, guys.